Perfect. All right. Good morning and welcome everyone to our manufacturing workforce law, the tough stuff, dealing with employee OVI and DUI. So this is a joint effort hosted by Dworken Bernstein Co, L.P.A, and the AWT Foundation. So my name is Juliana Petty, and I'm the Executive Director of the AWT Foundation. And we're so excited that Dworken was able to partner with us on this event. We know that it'll be something that's very useful for a lot of our AWT members and the like. So with that, I'm going to give you guys a brief overview of who AWT is and kind of what our mission is. So the AWT Foundation is a 501c3 nonprofit. We have about 300 to 500 members in the Northeast Ohio area. We have community members as our members, as well as educational members, and we're very heavy with manufacturing because promoting manufacturing careers is our main mission. We do that in a couple of different ways. You may have seen our signature Robobots competition, which is very similar to Robobots. It's really fun getting the students engaged at an early age and learning about, what manufacturing is, as well as our STEM to career camps for 5th and 6th graders, our junior bots, which is middle school combat robotics, and now we even have apprenticeship programs. So if you're a company who's really interested in getting, your next workforce trained, I'm going to drop you guys a line, I think, in the chat, my email address. Our apprenticeship program is 100% reimbursable by the Tech Credit Initiative, and AWT will actually help you fill out the application. So if you're really trying to get those next generation trained machinists, tool and die makers, mold makers, as well as we have the tool programmer, which is more heavy on the CNC. So if you're interested in any of that, just let us know and we'll get you started. And with that, I'll turn it over to Rick to let you know a little bit more about Dworken.
Hi, I'm Rick Selby. I'm a partner here at Dworken Bernstein. We're a firm with just under 30 lawyers. Dan Williams is here with me. He's in our criminal department. I run our commercial litigation department and handle a lot of our business, human resources, employment actions. We're in our conference room here in our Painesville office. We also have a downtown Cleveland office. We serve a lot of businesses in Northeast Ohio and representing businesses in all aspects, litigation, employment, transactional work. That's a big focus of our business department. What we're going to talk to you about today is DUIs, and particularly how they can impact a business, and I think the issues that as a business owner or business manager you should be thinking about. The two most common ways that a DUI is going to impact your business is, one, you have an employee who needs to drive for work. It's a delivery driver who has a CDL. It's an outside salesperson who's out making deliveries. They need a driver's license and a valid license to do their job. What happens if they get a DUI? The second is potential liability. If you have somebody who is driving a company car and gets into an accident while they are drunk, what impact is that going to have on you? We're going to start out today. Dan, as I said, is from our criminal department. He's going to give some background just on how DUIs work in Ohio and sort of how they can impact your business from the perspective of keeping an employee license and so forth. I'm then going to talk a little bit about the employment implications, hiring and firing employees under various circumstances involving DUIs. And also I'm going to talk a little bit about liability or potential liability and things you should be concerned about. So I'll turn this over to Dan. Go ahead.
All right, thanks, Rick. As Rick just indicated, my particular focus is in criminal defense, and a large bulk of our practice is in fact dedicated to DUI, OVI defense. And the reason for that being, just last year alone, there were over 25,000 arrests made in the state of Ohio on OVI-related charges, and that's just by the Ohio State Patrol alone. So that wouldn't even factor in your local police departments and other, sheriffs and other municipalities that may be out there looking for impaired driving. Over the past, 30 years, if not longer, Ohio's OVI laws and national OVI laws have been in a constant state of change, and that change has been in the direction of making the penalties and consequences harsher to try to crack down on impaired driving and the consequences that occur from that, primarily accidents and deaths related to impaired driving. So OVI is big business in the state of Ohio and big business across the United States in general. And when it comes to defending OVIs, I always let people know that just not any criminal attorney will do. OVI defense is a very specific practice that we engage in. You've got to stay on top of the latest testing methods, what machines are being used to test people, blood and urine analysis. There's a lot of science that goes into defending a DUI case that most people aren't aware of. And those of us that are aware of it know that a lot of that science is in fact junk science, and it's important that you have someone, a competent person to represent you if you or your employee may ever find themselves in that situation, to know what legal challenges to make and how to deal with these situations. So with that being said, I'll kind of just start with discussing some of the basics about Ohio's OVI laws. And just to kind of clarify, so OVI stands for operating a vehicle while impaired. They used to kind of be called DUIs. Other states may still call them DUIs. This is just the acronym that Ohio uses. And, the reason we use that acronym and it speaks to operating a vehicle is because you don't, technically speaking, have to be caught in the act of driving a motor vehicle in order to be charged or convicted with an OVI. What Ohio defines as operation is simply means to move or have caused movement to a vehicle. So if there is circumstantial evidence that would show, even if a car is found in a resting state and the person's not currently operating the vehicle, if there's evidence that indicates that, they were the one who caused that vehicle to be moved to that particular location, it's still possible to be charged and both convicted with an OVI. So that being said, there's a couple ways that someone can get charged. Ohio statutes are very complex when it comes to OVIs. There's what we call our basic driving while impaired violations, which don't specifically speak to maybe what the prohibited concentration of such substance may be in your system, but generally the state would just be required to prove that you were impaired. So in those situations, maybe they don't have a breath, blood, or urine test, but they have other evidence that they will use to indicate impairment. You can be just charged under a general statute. There are also what we call the per se violations, which include driving with a prohibited concentration of either alcohol or a specific controlled substance that's in your system, with 0.08 blood alcohol content being the threshold for what we consider per se impairment in Ohio. And that's not to say that if someone has a blood alcohol concentration of less than that amount that they can't be charged and convicted, and that's where that basic impaired charge comes in, because as we know, alcohol and drugs can affect different people differently, and someone who may be under what we call the per se limit of the 0.08 may still be exhibiting signs of impairment, and maybe they can't sufficiently operate a motor vehicle, and for that reason they can still be charged and convicted even if their concentration in their system isn't at a per se level. When we're talking about penalties that someone may be facing for an OVI laws in Ohio vary depending on your prior history. So OVIs are enhanceable offenses in the state of Ohio, meaning the more of these that you accumulate within a given period of time, the worse the consequences will get each particular time. And unlike most other offenses in Ohio, OVIs have mandatory minimum penalties. So most of the time someone's looking at a misdemeanor OVI offense, and that would be if this is either your first OVI offense in a lifetime or first within a 10-year period. What you'd be looking at is a mandatory minimum of 3 days in jail up to a maximum of 6 months There's mandatory fines with OVIs, anywhere from $375 up to $1,075. And as Rick indicated before, oftentimes the most severe consequence, aside from the, potential incarceration that someone faces, is the loss of licensure. And a driving license suspension is a mandatory penalty on an OVI offense. On a first-time offense, you face a minimum license suspension of a period of 1 year, and they can take it up to a maximum of 3 years, and that's at the discretion of the judge. Other possible penalties that someone could face include, requirements that they equip their vehicle with an interlock ignition device, which is essentially a machine that someone would have to blow into, and if it detects alcohol, the vehicle wouldn't start. The state may require you, or the judge, the sentencing judge, could require you to impose, put restricted plates on your car. So those yellow plates, often called party plates, as we call them in our industry, are a potential penalty that you may face, and become mandatory if you accumulate a number of these offenses within a specific period of time. So our goal, when we approach these, is always try to avoid having that OVI conviction in the first place, because once you do, it only gets worse from there on out if you ever find yourself in that situation again. And an OVI offense is something that stays on your record. It can't be sealed or expunged. And again, subjects you to potential future penalties that get worse as these things go on. And the look back period for these is a period of 10 years, and that increased a few years ago. It used to be only a look back period of 6 years for determining if someone's going to be facing enhanced penalties. Now that look back period is 10. And there are also additional consequences that include a 20-year look-back period when it comes to submitting to breath, blood, or urine testing. And that being, if someone has a prior conviction within the past 20 years, Ohio actually makes it a separate criminal offense to then refuse to submit to a breath, blood, or urine test if you're ever arrested another time for OVI. In normal situations, someone may be able to refuse a test without having criminal consequence, but if you have that prior conviction and it's within the past 20 years, then you're subjecting yourself to an additional criminal offense should you refuse to submit to a particular method of testing that the arresting officer asked you to do. And another situation where Rick kind of touched on, especially in the manufacturing industry, a lot of your employees may in fact hold commercial driver's licenses, and CDL holders are subject to a potential greater range of penalties, especially if they're in the process of operating the commercial vehicle. So if they're operating a commercial vehicle, it's actually criminal. That VAC level is actually a 0.04% rather than the 0.8, so half. And in fact, commercial drivers aren't even allowed to have any detectable amount of alcohol or a controlled substance in their system, even if it's below a 0.04. And they face consequences if they do, which would include a 24-hour out-of-service penalty, in which they couldn't drive their truck or their vehicle for the next 24 hours. If they're unfortunate enough to, be over that limit of 0.04, then possible penalties can include, for a first-time offender, a loss of their CDL for a period of up to 1 year. And if they ever get a second offense, then they're facing a lifetime CDL disqualification. So the stakes are very high for CDL holders. And CDL holders also don't really have the privilege of refusing tests, because if they do, they're also subjected to that CDL disqualification just for refusing a test, which again could be up to a period of 1 year. And if they have 2 refusals in a lifetime, then they're facing that automatic CDL lifetime disqualification, which could, put them out of business forever. Another potential consequence that we always discuss with our commercial driver's license holders, in most situations, a court may be willing to grant driving privileges to someone whose license has either been suspended for a conviction related to DUI, or if their license has been suspended as part of something called an administrative license suspension, which I'll get into in a little bit. But for CDL holders, Ohio's laws do not permit a court to grant any driving privileges for operating a commercial vehicle. So even if they may be granted privileges for operating a personal vehicle, getting to and from work, they can't drive that commercial vehicle for you while any active suspension is imposed on their license. So when we have those CDL holders who get charged, we have to act very quickly, usually at their very first appearance, to address any potential license suspension that may be in place to try to get them back to work as soon as possible. So what happens, when someone gets pulled over for an OBI? Typically, we'll see that the most common reasons that OBI investigations usually starts with just some basic common driving infractions. So someone didn't have their headlights on, someone didn't use a blinker, or maybe they didn't activate their blinker within a specific amount of time before they hit that stop sign. If you get your more sticklers, state patrolmen that are out there, they can and will pull you over for the most minimal driving infractions. So I always advise people, just in your daily lives, it's always good to use good driving practices and get in that habit of always using the blinkers, staying off your phone. Distracted driving is a really big reason why people get pulled over in the first place, even if an officer may not initially suspect that that person may be impaired. So it's good to use those good driving practices in the first place, always having your license, registration, and proof of insurance handy for when you do in fact get pulled over, so you can provide those things in a quick manner, knowing that the officer is going to be asking for those things, because the way they're trained, one of the reasons that they put out there as to why they suspected someone may be impaired is because maybe they were fumbling around or couldn't find their license or their registration. And those are all little things, that can turn a basic traffic stop into an OBI investigation very quickly. So in those situations, again, it's typically that common driving infraction that's going to initiate it. Once that officer approaches the vehicle, especially, with Ohio State Patrolmen, if they're out patrolling, if it's the nighttime hours, your peak hours, weekend, for when, the most impaired driving is taking place, they're on alert and they're, trained to look for that almost immediately. So, as soon as that window goes down, they're, going to be, trying to poke their head in there, see if they can detect any odor of alcohol or any illicit substance, ask you questions about where you're coming from, where you're going, if you've had anything to drink that night, that's how it turns into an OBI investigation very quickly. And it's our natural inclination to want to be open and honest with the police officers, and think that the more honest you are with them, the better your chances may be. But generally speaking, in my experience, the more information you give them and the more honesty you have, just provides them with further probable cause to, extend that traffic stop, ask you to get out of the car, and start trying to put you through some field sobriety tests. So a lot of the common questions I get asked, what do I do if I'm in that situation? The officer asks me, well, you're under no legal obligation to answer any of his questions. Now, if you just sit there and remain silent, he's probably going to, that may raise a little suspicion in and of itself, but otherwise speaking, you're not obligated to answer his questions. And you can refuse to do that or simply just indicate that, you haven't had anything, because again, any information that you provide them is going to serve as a legal basis for them to extend that traffic stop and, potentially place you under arrest. Now, if an officer actually asks you to get out of a vehicle, it's generally one of two things. At that point, he thinks you're impaired and he's just going to start putting you through some tests. And in his mind, you're already under arrest for OBI. The other situation where they're going to ask you out is, maybe they don't have a good indication that you may be impaired, but they have, they suspect a little something from, whatever information you gave them, and they're trying to get up a little closer to you, smell your breath, watch your mannerisms as you exit the vehicle. Do you have any issues with your balance or coordination? And we'll see those things find their way to the police reports a lot of times, when they indicate that they asked the individual out of the car and, they stumbled around or had to hold on to the vehicle for support. Any little thing that they can do, which could be perceived as an indicator of impairment, they're going to put in those reports and try to use as the basis of why they put you through these tests. Because otherwise, unless they're able to point to those things, there's no reason that they have to detain you and ask you to go through field sobriety tests. Speaking of those tests themselves, the officers won't tell you this, but there's no legal obligation that you perform a field sobriety test. Again, most people want to let the officer know that they're being cooperative and they will go along with those tests. And, unfortunately, a lot of times that's a bad decision to make because there's, very small clues that these officers are trained to look for when they're administering these tests. And you may otherwise think you performed, phenomenally on them, when he's just going through checking his list of little clues that he's trained to look for. So in these situations, there's basically 3 field sobriety tests that you're going to be put through. 2 of which, are, actual walking and balancing tests. One called a walk and turn test, where they'll instruct and demonstrate you to take 9 heel-to-toe steps and turn around. Another one's called a one-leg stand test, where they'll instruct you to lift, either foot off the ground 6 inches and count out loud until they tell you to stop. They're timing you for a period of 30 seconds. Obviously, in most situations, especially in these, there's obviously nerves that are involved in any police encounter. Sometimes you're performing these tests on the side of a highway as cars are running by you, at 70 miles an hour. So they're nerve-wracking situations. And even absent any impairment, people will exhibit clues that the officers will interpret as impairment when they may have nothing related to that. People with leg, back, knee issues, balance issues, weight issues, oftentimes perform very poorly on these tests. And so, if they do in fact perform these tests, it's kind of setting them up for failure. But everyone should know, and what most people don't know is, again, that there's no obligation that you submit to field sobriety testing. Now, if you refuse to submit to the tests, I often advise people to, give the officer a reason as to why you're doing that. Just don't say, no, I'm not doing your test. Be polite at all times with these officers. Let them know, hey, I have knee, leg, or back issues. I don't feel comfortable doing these. How is the officer going to interpret that? Well, he may still place you under arrest, and 9 times out of 10, they will still arrest you. But again, in terms of me being able to defend your case, the less evidence that they have as to the basis for believing you're impaired, the better position it puts me in when I'm, attempting to defend that case. Another thing that people will be subjected to when they go back, if they are placed under arrest, is they'll be asked to submit typically to a breath test, but blood or urine tests are also possible. When it comes to the breath test, there are certain machines that are certified in the state of Ohio. That doesn't mean that these machines are fail-proof. There's a lot of litigation that has occurred over these issues and is still ongoing as to the reliability and accuracy of these tests. So I always advise people to take them at your own peril, because that's obviously the question that I get asked the most is, hey, do you blow or you don't blow? When I tell everyone, listen, only you truly know, what the state of your impairment could potentially be. If you've literally only had, 1 or 2 low alcohol beverages, then, maybe there's a chance that you may pass that test, or maybe you're just slightly over the prohibited level, which even if they get that, that's still good ammunition for me to use in terms of defending your case to show your cooperation and that you weren't overly intoxicated. Obviously, if you've known you've drinking to the point where you're likely to be, well over that 0.08 limit, which isn't very hard to get to in the first place, then submitting to that test is, most likely going to result in a failed test, and again, provide the state, the prosecutor, additional evidence of your guilt. Now, there are consequences if you do refuse to submit to a test, and that's in the form of what's called an administrative license suspension, which can get imposed by the DMV even before you've been convicted of everything. So a lot of laws in Ohio and in other states are called implied consent laws, which basically state that if we issue you a license to operate a vehicle within our state, that if you ever get arrested on suspicion of an OVI, that you're going to agree to submit to a test. And if you refuse to submit to those tests, well, then we're going to immediately seize your license and place you under a suspension. And that's that administrative license suspension, which will get imposed if you ever refuse to submit to a test, or if you take the test and test over it. Now, what you can do with that is appeal that directly to the court. That often needs to be done at that very first appearance, to try to get the court to put what's called a stay on that administrative license suspension to say, hey, Your Honor, we believe there were issues with this arrest or with this machine, or that my client didn't refuse, or that something went wrong, and we're going to raise a challenge to those results, or on the basis of that refusal, and we're asking you to put a stay on that license suspension in the meantime, so that we can get this person back on the road and back to work as soon as possible. That's even more important for commercial driver's license holders who, again, face that possibility of that 1-year suspension for refusing a test, lifetime on a second. So even before they've been convicted of anything, they're out of work. So it's very crucial for CDL holders to be able to appeal that administrative suspension very early on in the process while you're still fighting the underlying charges itself. As far as potential workplace consequences, as Rick kind of hit on, the biggest issue is with these loss of driver's license. If someone can't get to work, they can't work. If they operate a commercial vehicle, they could be prohibited from doing that. A lot of times we'll also see issues for people who may have certain state-issued licenses and certifications as it relates to powered industrial trucks, or those are your forklift operators, anything, tow motors, cranes. Now, Rick may, be able to speak to this, but I don't believe there's any OSHA requirement, that someone actually even have a driver's license and able to operate a tow motor or a forklift. But oftentimes employers will have that specific requirement that they have to be a valid driver and also state certified in order to operate that type of machinery. And again, if you're going before any state licensing board, these individuals may be subject to background checks through the state. And having any sort of criminal conviction or DUI conviction can put them in jeopardy of losing licensure or certification as far as operating a vehicle or anything else that may be related to the course of their employment. A lot of times, in my experience, we also get into trouble, with outside sales reps. Obviously, we know we're not living in the days of Mad Men past where we're, drinking heavily throughout the day. But, the reality of the modern business situation is a lot of business is done over the golf course or in a restaurant or bar, and, when there are drinks and cocktails that are being had. And a lot of times we may see your outside salespeople maybe operating a company vehicle that may be covered under a commercial insurance policy. You may be held liable for the actions of those people, when they're out there, and if they find themselves, getting charged with an OVI, especially if a accident is involved that results in damage to persons or property, is where your big exposure is going to come from. So, best practices, for you as employers is always, in my opinion, to have written policies in place that will address these things. And, Rick will be getting into that a little more. But having a written policy in place, with procedures, that are taken if someone is charged, with the potential consequence that it could lead to termination, is actually good ammo for me to use on my end in defending these cases, especially for first-time offenders, to be able to present to a prosecutor or court to show that this person, could end up losing their job if they're convicted of this. And if we have a policy that we can point to that specifically states that, then that's good ammunition for us to use in defending their cases. And again, with the commercial insurance policies, you're looking at potential impacts to your insurance rates, regardless sometimes of whether or not there's a conviction or not. So you want to make sure that you're covered on your end as far as dealing with those things. And one thing I actually neglected to mention, especially given our location up here in Northeast Ohio and our neighbors to the north, a lot of our businesses do a lot of business, with Canada. And if you're sending any sales reps or representatives, to Canada to engage in any business, Canada can actually deny entrance to anyone with an OVI or DUI conviction on the record. And there would be a process that they would have to go through, either getting what's called a temporary resident permit, or even better, a criminal rehabilitation certificate, in order to get entry into the state of Canada to conduct any business. But again, you don't want to put yourself in a situation where you're, facing that in the first place, because that's just going to be, added difficulty and expense in trying to get those things accomplished in order to be able to cross the border there to conduct business. And as always, advise your employees the best practice would, would be, if you've had too much, do not get behind the wheel. Hopefully they have the company credit card handy when they're having these dinners in the first place, and always better to get that Uber or Lyft, than to be paying the legal expenses that are involved in defending one of these cases. So with that being said, I'll transition here to Rick, and he can kind of get in a little more detail, about your liability and your exposure in these situations.
Thanks, Dan.
Yep.
Appreciate it. So the first thing I want to talk about is, from an employment relation point of view, what you can do with an employee who has been convicted of an OVI and or charged with OVI. The one law that probably has the biggest implication here, and you need to be cognizant of when you're dealing with the employee and how you present things to the employee, is the Americans with Disabilities Act. Taking an adverse employment action against an employee because they're an alcoholic or because you perceive them as an alcoholic can be unlawful discrimination. Alcoholism is recognized under the Americans with Disabilities Act as a disability, and you cannot take an adverse employment action against an employee because they have a disability. That being said, you can take disciplinary action against an employee because of how their consumption of alcohol affects their employment. For example, in the context of an OVI, if you have an employee who needs a CDL to do their job, or they're a salesperson who needs to be able to drive and visit customers, or an employee loses driving privileges and can't get into work, you can take a disciplinary action, including termination, against them because of their inability to do the job. If the CDL is a qualification for their job and they don't have the CDL, you can take, an employment action against them because of that failure to meet the qualifications of the job. It's always important to put it in that context. The place where the ADA comes into play is where an employee who has not impacted their work at all, they come into work, they're doing all the job, and for example, comes to you and says, I'm worried I'm an alcoholic, I'm checking myself into a program, I need 3 weeks off to go through an alcohol rehab program. In that circumstance where there's been no adverse impact on their ability to do their job, allowing them that 3-week leave to go through a program like that might be considered a reasonable accommodation for their disability of alcoholism. Under the ADA, you have to provide employees who have disabilities a reasonable accommodation. Now, that's not a get out of jail free card for an employee who has already had problems. If they come in and they've missed a week of work or they got an OVI and they've lost their driver's license, and they come to you and say, hey, look, I'm an alcoholic, I would like an accommodation, I'd like to go to this. You can discipline them for the impacts that has had. just like any other employee who, if they, weren't able to come to work, if they weren't able to perform their job, regardless of the reason, you can treat an employee, even if they're an alcoholic, the same way you would treat any other employee who has the same limitations on their ability to perform their work or the same work-related problems. You just can't do it because they're an alcoholic. So if you have a situation where you have an employee who's been charged or convicted of an OVI and you want to take disciplinary action against them, you're going to want to make sure you put that in the context of how that has impacted their ability to perform their job, as opposed to just doing it in and of itself because you believe that that's an indication that they're an alcoholic. One of the places that you can really help yourself is if you have ahead of time written policies laying out what the disciplinary measures are going to be for somebody who's convicted of a crime. And you probably want to have these written broadly, so they would encompass an OVI, but the same way if you have somebody who's convicted of theft, you may have concerns about, protecting your property and so forth. Having policies in place ahead of time that lay out what the disciplinary ramifications are going to be for these offenses, it helps too, because then you are you're disciplining the person for the criminal conviction and the impact that has on the employment and the work setting, as opposed to taking an action against them because they're an alcoholic or you perceive them as an alcoholic. So the way you explain the discipline, the context you put it in, having those policies in place ahead of time are all important to help avoid any employment liability if you take disciplinary action. The other thing to think about on the other side of this is, if you have a key employee who you don't want to lose, who is potentially facing these charges, making sure they are getting competent, adequate representation in their criminal case to perhaps avoid some of the consequences of the license suspension, all of those type of consequences, may be something you want to do. If you decide, I don't want to discipline this employee, I want to help them work through this, making sure that they have appropriate, adequate representation in their OVI case is something you may want to do. And I've seen situations where employers reach out and say, I want to make sure that this person has good criminal representation. So, when you're faced with that situation, you want to think of how you want to handle it with respect to that employee, and thinking about how you're going to handle those situations before you're faced with them, I think is an important part of that. And coming up with policies and procedures, and having thought about this before it's an emergency, and you get that call at 1 a.m. from somebody and you have no idea what's going on, or you get into work the next morning to a voicemail from somebody who's telling you this happened. Having thought about this ahead of time is a key to then knowing how to react. The next thing I think it's important to recognize is areas where you as a business can be liable for an accident caused by an employee, particularly operating a company vehicle. I think there are really two circumstances and two types of causes of action that you want to be aware of and you want to think about. The first has to do with liability if somebody is driving a company vehicle and they are in an accident and are charged with OVI. There is going to be potential liability against the company. And one of the things you have to be aware of is that in a lot of instances, the person who's the victim of the accident, when they're going to get representation to bring a claim for their personal injury action, they're probably going to be looking more to liability of you as the employer. You're more likely to be the deep pocket than the employee is. You know, making sure that you have insurance in place that covers employees while they are operating company vehicles is imperative. You know, you periodically want to review those commercial coverages with your insurance agent. Making sure you have that coverage in place is important because, you know, if that circumstance happens, the personal injury attorney is far more likely to be looking to go after you than they are the individual driver. With respect to when a company can be liable, generally a company is vicariously liable for their employees while they're in the course and scope of their employment. That can at times be a difficult thing to ascertain, and there are circumstances where that could be an issue in any personal injury type claim against the company. So the farther afield it gets from them doing their actual business. For example, if an employee is driving a delivery truck and they're supposed to be making deliveries and they stop off at the bar for 3 hours in the middle of the day, unbeknownst to you, and have too much to drink and then get pulled over, you're going to have an argument that they had gone on, in court it's called a frolic, but they were, when they went to that bar for 3 hours, they were outside the course and scope of their employment, and that was outside of what they were supposed to be doing for you. Now, it may be a very different circumstance, as Dan was talking about earlier, if you have, for example, a salesman who is out entertaining customers or clients, and you took them golfing at the local country club and they were drinking while they were out on the golf course. You know, that is much more likely to be considered that salesperson was drinking in the course and scope of their employment. They were actively soliciting business. They were meeting with clients and customers. That is far more likely to be considered inside the course and scope of the employment. One of the things you can do to try to give yourself some protections and give yourself a argument that the person was outside the scope of their employment when they were operating the company vehicle under the influence is to have written policies and procedures in place that make it clear that an employee is not authorized to operate a company vehicle while they're under the influence of alcohol. Policies that prohibit employees from excessively consuming alcoholic beverages while at business meetings or sales meetings or entertaining clients. Certainly with respect to a delivery driver who's operating a commercial vehicle, there should be an absolute prohibition on an employee in that circumstance consuming any alcohol. But having those policies and procedures in place that have been communicated to the employee and that the employee has signed off on the employee handbook, acknowledging that they're going to comply with all of these rules and regulations. When an accident like this happens, you've got a much better argument that they were operating outside the scope of their employment, that they were specifically prohibited from doing this under the policies of the company, and that you give yourself that type of defense in those circumstances. Again, those are the type of things that you want to think about ahead of time. Having knowing that you're going to have employees operating company vehicles, thinking about how all of this is going to impact your business and how you want to handle these things, and having the appropriate policies and procedures in place always puts you in a better position than it is reacting to something after it has already happened. Putting yourself in a position, I oftentimes, clients are sometimes hesitant. Well, I don't want to, pick up a $100 bill here and a $200 bill here, and I didn't want to waste your time. Those clients spend far less money on attorney's fees bills than the one who calls me and says, I fired this guy 6 months ago and I just got this lawsuit in the mail. Making that call to whoever your corporate counsel is when the problem has, or to work through with them, putting in place the policies, procedures, how you want to handle this ahead of time so you're prepared, and is going to put you in the position to put your best foot forward if you ever get sued in these circumstances. Generally, in the long run, is going to save you money. I always encourage people to think about these things ahead of time than after it's too late.
And just before I forget, but not to butt in, but one more thing to add, it's, not only potential civil liability that an employer could be facing for the actions of their employees, but there was a criminal charge called wrongful entrustment of a motor vehicle, which would come into play if there's any evidence that would suggest that the employer had knowledge that their employee could potentially be operating the vehicle while impaired. So, if there's any contact that they have after they're leaving a meeting or restaurant or bar, and there's indications that that person may have consumed too much alcohol, or if they're aware that the person has an open and active suspension on their license, and they permit that employee to operate a company-owned vehicle, and that person gets into an accident, then the employer is also exposing themselves to potential criminal liability in addition to the civil.
And that transitions well into the next potential area of liability that you need to think about with respect to an employee who is operating a company vehicle. If you are aware that an employee who's going to be operating a company vehicle has a history of OVIs, has been previously convicted, has had them while they were employed with you, and they get into a subsequent accident down the road where they are impaired, you could be looking at a civil case for negligent hiring or negligent retention or negligent entrustment of the vehicle. And the theory would be that you as an employer knew that this person had this potential. You knew this was a problem. They had a history of this, and that you were negligent in either keeping them on as an employee or hiring them or giving them a company vehicle that they had full use of. The more serious the person's history is with these type of offenses, the more likely you're going to have concerns regarding that type of liability if they get into another accident. You know, when you're looking at the liability that I was talking about earlier, where whether they're in the course and scope of the employment. If, for example, you have a company car that they can use for all of their personal driving, they take it home and they use it 24/7, not just when they're in business. If you know this person has a history of OVIs and those type of problems, and you give them a company vehicle, even if you may not be vicariously liable for the accident itself because it happened outside the course and scope of the employment. If you provided a vehicle to this person to use 24/7, knowing that they have this history, you could find yourself facing a negligent entrustment and that you provided a vehicle to somebody. Certainly, you're going to want to have policies in place that address that they need to have a proper license. You know, you can get into a negligent entrustment claim if somebody has lost their license or is under a license suspension and is operating that company vehicle, and you had knowledge that they had lost that license. You can, you know, there could be a negligent entrustment argument there that you should have taken steps to have that company vehicle taken away from them, somehow preventing them from operating it. So it's not just that immediate vicariously liability. You know, you need to think about if you have employees with histories of these kind of offenses who are driving company vehicles, what type of liability that can expose you to. That also, you know, one of the things that you want to make sure with respect to your commercial policy, some of the policies will have requirements as to what to have coverage for a driver, what requirements that, you know, they're a properly licensed driver. You know, there may be exclusions with people for coverage for people with these type of histories. One of the things you want to make sure with your insurer is that all of your employees who are operating company vehicles meet whatever qualifications the commercial insurer has on their policy for coverage. You don't want to find yourself in a situation where the insurance company is denying you coverage because the employee you had operating that company vehicle didn't meet some qualification that the insurer had. And they're typically going to be that they have to be a licensed insurer, but I have seen policies in the past that, you know, will have exclusions for people with, you know, poor driving records. So understanding what those qualifications are under the insurance policy is something you should definitely talk to with your insurance agent. So we're at about 10:55 here, and I know that Juliana wanted us to leave 5 minutes for any questions at the end of this. So if anybody has any questions, I'm not sure how we can communicate those, but we're open to all of those. Thank you for participating. Again, I'm Rick Selby. This is Dan Williams. We're both at Dworken Bernstein, and we're more than willing to help any of you with these problems when they arise, or as I talked about, helping you to prepare for them ahead of time and think about how you want to handle these situations before they occur.
Thanks so much, Dan and Rick. That was awesome. Getting down to, the preventative measures and whatnot. You both are clearly experts in your field. As Rick said, we are taking questions right now, so please feel free. Anyone who's participating, go ahead and put them in the chat box. I'll give you guys a couple of moments to formulate your questions that you have, and I'll get us started with the first one. So Dan and Rick, you guys talked a lot about preventative measures, and but what happens if I'm an employer and I find out that one of my employees has a potential for OVI or DUI? I'm kind of in that damage control mode. How do I go about that? What are my next steps, and how can I get in contact with the Dworken team?
So you can reach us. We have our website, dworkenlaw.com. The number here in the Painesville office is 440-352-3391. You can reach either one of us via email. My email address is rselby@dworkenlaw.com. Dan's is dwilliams@dworkenlaw.com. You can certainly reach out to us and handle that. Particularly if this is a key employee that you want to hold on to, and you want to try to help them with the defense of the DUI to maybe avoid some of the consequences with respect to suspensions, to make sure that they're raising all of the defenses that are available to them. One of the things you may want to do is put them in touch with a criminal lawyer as soon as possible. We have a criminal law department. Dan's available, and Jeff Cakes is also available. Both of them handle DUIs. You can contact either them directly or us at the front desk. If you
we do have the 24-hour on-call cell phone as well. I'll have to grab that number real quick. I didn't never remember that number. But my personal cell phone, I always make myself available, is 440-477-3445. Obviously, when we're dealing with these situations, it's usually past business hours are typically when these things are taking place. But it's very important to be able to speak with an attorney as soon as possible. I always advise people, prior to submitting to any test, to always ask the arresting officer if you can speak with an attorney prior to doing the test, and most of them will not permit you to do that. And there's actually no legal requirement that says that they have to permit you to talk to an attorney before submitting to a test. But if you ultimately decide that you're not going to take the test, or even know ahead of time, it's always good to express that you wanted to talk to an attorney in the first place. Because if I'm making an explanation to a prosecutor, or if it gets as far as a jury trial as to, why would someone ever refuse a test if they hadn't been drinking? Well, my client simply wanted to discuss this with an attorney prior to doing that, and this officer wouldn't give them that basic right that most people have in these situations when they're dealing with law enforcement. And if they do, then obviously you can get the advice directly from me at that point, because these things happen fast, and there's a lot of decisions that need to be made quickly, especially when it involves the loss of a license. And your first court appearances on these matters. By law, they're supposed to schedule your first appearance within 5 days of the date of the arrest. So you're going to be in court very quickly. There's a quick turnaround, and actions need to be taken either prior to or either sometime directly after that first appearance to try to get that person back on the road.
Great, thank you guys. Last question we have here. So Rick, you especially talked about, getting ahead of this issue with your policies and procedures. So what if I'm an employer and I want to start drafting those? How do I go about that? Do you guys specifically at Dworken, are you able to help in that?
I do. I regularly, I review employees' existing handbooks and make suggestions. I also can put them together from scratch if you don't have one. The two things I always advise employers with respect to the handbook. There are some basic legal requirements you want to have in there that you want to have to protect yourself in various circumstances that you want to have in every employee handbook. But you also want to make sure that it is tailored to how you do business. So it's important, you know, I've seen companies that have handbooks that they got it drafted 20 years ago, and, you know, they have it in a drawer somewhere, but then when you pull it out, you know, they have 15 policies that they don't do any of those things. And, you know, that in itself can create problems for you because you're not following your own policies. And so there's certain things that, you know, it's not necessarily legally required, but you want to make sure that your handbook is consistent with what you actually do. So sitting down with legal counsel and having them periodically, you know, do those updates to, one, make sure they're legally up to date, but also to talk through, you know, how am I doing these things? Does the policy I have written there match up with my actual procedures?
Perfect. And with that, we are 1 minute over. So I just want to say thank you again, Dan and Rick. It was a pleasure having you guys. It's always great to learn from the experts, and thank you to everyone who was on the webinar today. So I'm sure we'll do more of these in the future, and thank you guys again.
All right, anytime. Thank you.